Hi, I'm Mike Wasylik, Florida Foreclosure Defense Attorney. It's 2 days before Christmas, and I'm here in Florida's Panhandle, Santa Rosa County, just east of Pensacola. And I'm here today for a trial. And one of the issues that's coming up in today's trial I want to talk to you about, specifically the issue of reformation. What is reformation, why it matters to you, and what you can do about it. Reformation, quite simply, is the question of whether or not there's an error in the deed of the mortgage, and the plaintiff, the bank, is asking the court to correct that error. Usually it's an error in the legal description. Sometimes it's when a party's been left off or the wrong name is on it. But there's some error, some kind of Scrivener's error that the bank is asking the court to correct. Now, this appears in many foreclosure cases, and the reason it's important to know is that if they don't reform the mortgage or the deed that the lien is based on, they can't get a foreclosure because they're foreclosing on the wrong property. So they have to fix the legal description, or if it's the wrong names left off, they can't include all the parties. So they need to get that reformation action successfully in order to foreclose the lien. Now, there are two things you need to know about reformation actions. One is that they have a limited time period. There's a statute of limitations that applies to them. The second thing you need to know is that there's a defense as to indispensable parties. In other words, if you try to reform a deed or a mortgage and don't name everybody who is a party to that deed, you may have a way to dismiss that action. So if you have a foreclosure case and you have a reformation count in there and you have a question about it, please give us a call. Again, I'm Mike Wasylik, Florida Foreclosure Defense Lawyer, 352-567-3173. That's 352-567-3173. Happy holidays.